Joining me, this is EBRE number 14. This is a follow-up to the one that I just did, 13, which was an intentional torts introduction that was part of the assault and battery part. We're going to cover some other intentional torts, but I read a practice exam at the end of 13 and said you can do it if you want, and that I would come back and I would I would create a response to this because I couldn't find the model answer. And so it's kind of like a caveat that this is from my knowledge. So if you see something else or have any questions, this is what I saw as far as the issues in the call of the question, the best way to answer it. I'm pretty good at essays, but some of them aren't the best. But let's go ahead and read this. And I did want to make one clarification on the content from the last time. So first of all, let's quickly review the intentional torts. Okay, so intentional torts to the person, it can, when you look about torts, right, and you categorize them, you break them down into categories and elements, you're going to do it based on torts to the person, torts to the property, torts to personal interests like defamation, and then you're going to put down the defenses, and then you're going to do the remedies. So with intentional torts, it's to the person: assault, battery, false imprisonment. To the property, it's trespass to land, chattels, and conversion. And then with the personal interest, defamation, invasion of privacy, IIED. You also have NIED, but that's negligence. So when we're looking at a fact pattern, and we're going with intentional, try not to mix them up. But here's the thing: that particular essay at the bottom. Oh, before I get to the essay at the bottom, I'm just scrolling through the other one, and I wanted to say that with the assault, there were a couple of categories that I was pulling apart, and we talked about the prima facie case. And damages are not required. However, you have to have this imminent or apprehension, and when you're answering it, you're going to show that in the fact pattern. So words alone are not sufficient, okay? There has to be some volitional act tied to the words that make it an apparently immediate threat. In other words, if somebody doesn't have the apparent ability, or it's a joke. Now here's one thing that I'm not going to go over this too much, but I wanted to just clarify one area because I kind of misspoke a bit. Basically, when I did the last one, I used some poor examples because I was doing it off the top of my head on conditional threats. And I just wanted you to kind of like pause it and read it. And the example I forget, I was using sarcastic or facetious conditional threats. I might have misspoke a little there, so just double check on that. Okay? So, but I wrote it down. Okay? So there's these nuances in here, and sometimes, when you're on the fly here, it's hard to. So let's look at the answer here to the essay. Let's just get down to business. I'm going to try to get through here. Here's the essay. Now, if you already heard it, maybe I should just quickly review it. Okay, so here's the, this is a racehorse. I'll tell you what. I went over, and it's not just intentional torts, it's also negligence. And I thought it was, initially I thought it was just intentional, but I guess I did recognize it was negligence. I just did this now. I just answered it. So, Diana, age 16, lives at home with her mother, Mary, in a state where the age of majority is 18. I honestly think that's a distractor because she's 16. So, and Mary's aware that Diana had recently exhibited some sometimes violent and delusionary nature, and she was diagnosed as schizophrenia and has attacked persons in the neighborhood. Medication that can control Diana's behavior has been prescribed, but without Mary's knowledge, Diana has stopped taking it. So a week after Diana stopped taking her medication, she approached the neighbor Paul as he walked along the sidewalk fronting Mary's home. When she was face to face with Paul, Diana, without provocation, gestured threateningly and screamed, "I know you're out to get me, and I'm going to get you first," and then strode away. Paul, who had no knowledge of Diana's mental illness, phoned Mary about the incident. Mary told Paul, "Diana has sometimes made threats to others, but I don't think she will try to hurt you, and I assure you that this will not happen again." Paul believed Mary's assurances, and for this reason, he didn't seek to avoid Diana. Mary questioned Diana about the incident, scolded her, and asked if Diana was taking her medication. When Diana said she was, Mary didn't pursue the matter. 2 days after Diana confronted Paul, Diana saw him raking leaves, which had fallen into the street, fronting their adjoining homes. Diana got on her bicycle and rode it as rapidly as she could, directly at Paul. Although Diana swerved away from Paul at the last moment, Paul reacted by diving to one side. He struck his head on the curb and suffered a severe concussion and facial injuries. Paul has sued Diana and Mary, alleging torturous causes of action. Is Paul entitled to recover against Diana for assault? Discuss. Battery. Discuss. Is Paul entitled to recover against Mary on the ground that Mary was negligent as to Paul? Discuss. On the ground that Mary is vicariously liable for Diana's conduct? Discuss. Okay, so basically, this is what I wrote, and I wrote this up here, and I started doing it, and then I came back and I finished it, so I just finished it. Is Paul entitled to recover from Diana? Actually, I misspelled that. Let me fix it. 4, assault. Well, I saw 2 incidences where you might think of it as assault. So the first one was, I put a 1 next to the assault, and I said assault is the intentional causing of the imminent, harmful, or offensive contact of another. So you got your rule without consent or privilege. Then you have your issue. So I broke it apart into 2 encounters. You could do it any way you want, but that's just the way I did it. So there were at least 2 encounters that seemed like assault to Paul. Here on the first occasion, Diana intentionally ran up to Paul and yelled, "I know you're out to get me. I'm going to get you first." A reasonable person in the same or similar circumstances might be alarmed by this behavior. However, the "I'm going to get you first" statement and leaving is apparently not imminent in nature. This threat to harm apparently is not imminent. Oh, I repeated myself. Okay, that's not good. You should just say it one time. Thus, the first incident, while bizarre and threatening behavior, it does not qualify as assault because it does not have an immediate harm or apparent ability involved. This behavior is likely typical unmedicated behavior of a paranoid schizophrenic. The fact pattern indicated that Diana was not taking her medication and lied to her mother. She was 16 years old. However, the neighbor did not know of her medical history. Diana can be held responsible for her behavior even if she has a mental illness and did not take her medication. Thus, the first incident will not be a full assault. However, it was a warning of the next assault. Assault 2, volitionally barreling toward Paul on a bicycle as if to run him down. Okay, so if you're doing this on a essay, you could wind up, having typos, missing a few words. And when you're taking the bar and you look at the answers that passed, they don't have grades on them, but they do show that the whole thing had passed. And they were chosen as one of the more exemplary ones. So even those have typos, so not to worry. Okay, so now, since I already discussed it, save time, I wrote assault, discuss, supra. Diana intentionally got on her bicycle and charged at Paul, cycling very fast toward him. This was an intentional threat to harm with a maniacal demeanor. This suffices as a gesture, and it was close enough in time to the first attempted assault when she yelled at him and charged at him but swerved away just 2 days earlier. A reasonably, by the way, I kind of mixed the fact patterns because when I read it again, you have to keep reading it a couple times. The first time she walked away, the second time she swerved away, and I was thinking, I don't know why I was thinking she was on the bike the first time. Sometimes stuff like that happens because it's a lot of stuff to do and you're trying to get your timing down. But anyway, so I'm kind of in a hurry myself. Anyhow, so let's get back to this. A reasonably prudent person would be in fear of a harmful or offensive contact by this encounter. Even though Diana is mentally ill, discussed above, she can form intent and be held responsible. Diana completed an assault this second time by causing Paul reasonable apprehension of a physically harmful touching, which he responded to by attempting to dodge her, hurting him. I probably should have explained that, he went on the curve and hit his head. Okay, so thus Diana assaulted Paul 2 days later and more. Battery. Let's push this back up a little higher. Intent to cause a harmful or offensive touching to the plaintiff's person and causes the actual harm. Okay, so here Diana sped toward Paul on her bicycle and Paul tried to mitigate the harm but wound up sustaining a concussion and facial wounds. Okay, transferred intent battery. Okay, so she didn't knock him over, but she was the but-for cause of him getting knocked over, right? So let's go with the transferred intent. There's actually 2 types of transferred intent, but we're just going to talk about this type. You can transfer the actual battery in torts, and you can also transfer the person. In other words, if you throw something at one person, but it hits another person, that's another type of transferred intent. So in other words, you intended something, you had intent. It just didn't work out the way that you intended. Or at least you generally intended. So here Diana meant to charge into Paul and hurt him. He was able to be hit by her body weight and her bicycle. He was not able to be hit by her body weight and her bicycle. But he did fall and hit his head, suffering concussion, facial wounds. While Diana did not swerve away on this second time, and actually she did swerve away on the second time, so I'm catching it on the second time around. But anyway, so she charged at him intending to knock him over with full force of her bicycle and body. So actually, we don't really know if she swerved away after he fell, or I think she did. She swerved away, so that doesn't mean she didn't intend it. So anyway, so let's just say this. This intent for one harm, where the act of carrying it out causes another harm, then the intended harm, the resulting harm, is said to transfer. Thus, Diana's battery intent is transferred to the injury sustained in Paul's mitigation of the direction and force of Diana's assault and battery toward him. That's kind of a mouthful. Maybe I could have said it more simply. It's kind of late at night. It's like past 11:30, and I'm trying to get this in because I promised I'd do it. So, anyway, defenses. Diana has no defenses, even if she had a delusional belief. It was self-defense as a product of her mental illness flare due to her stopping her medication for over a week. Thus, Diana doesn't have any defenses. Now, she might try to bring up self-defense, but that's not going to fly because they go by the reasonable person standard. She didn't. She stopped, and even with her age being 16, doesn't matter because they said the state, 18. But anyway, okay. The second call, the question is Paul versus Mary. That's the mother. Is Paul entitled to recover against Mary on the ground that Mary was negligent as to Paul? Now, whenever you hear a negligence call, which is not part of intentional torts, you're thinking duty. And I have a whole bunch of videos on that earlier. I started with negligence instead of because negligence is like 50% of all the questions on the, I think it's on the MBE or the essays. It's like a lot of the questions are devoted to negligence. So you got to break it apart. And I did a couple of videos describing the different types of duty. But basically, this is a general answer here. A duty of reasonable care based on a relationship status to act as a reasonable person, you could say prudent, in the same or similar circumstances. So there's two main theories on the duty of standard of care, and the Cardozo majority is that you owe a duty to all foreseeable plaintiffs. Now with Andrews, now this is from the Falscraft case, if your memory's not so fresh, or you're new to this, there is no duty unless there's a special relationship. So here, Mary's the mother of a teenager that is schizophrenic, and Mary has a special relationship with Diana as her parent and custodian. Therefore, under both Andrews and Cardozo, Mary has a duty of due care in the same or similar circumstances. Let's get to breach. Breach is falling below the standard of care, which is the duty of due care. Should I put that in there? I don't know. I didn't finish the sentence. You can tell it's late. Okay, Mary was made aware of Diana's first threat to Paul. When Mary reassured Paul that Diana is not going to harm him, Mary then questioned her teenage daughter about the medication. Mary knew that Diana had a history of being paranoid, delusional, and defensively attacking others, and only scolded Diana without following up on why she was exhibiting this behavior, despite claiming to be on her medicine. A reasonable person would check their child's medication on the spot, asking them to bring the medication, seeing how much is in there, and then contacting the psychiatrist about this and the incident. A reasonable person would not reassure Paul that Mary was not a threat due to her history. Thus, in failing to act as a reasonably prudent person to mitigate her daughter's behavior with the neighbor, Mary has breached her duty of due care. This is my opinion, based on my analysis. So, you have rule, IREC, issue, rule, analysis, conclusion. Thus, at the bottom of each of these when you break it apart, at the bottom of each, therefore, that's the conclusion. Anyway, so, actual cause. Wait a minute. Breach. Okay, wait. Did I finish breach? Thus, in failing to act as a reasonably prudent person to mitigate... Yeah, I read that. Okay. Actual cause. The but-for test. The actual cause of the damages. I did a whole section of causation. If some people have trouble with causation. So the actual cause is the but-for cause. The actual cause of the damages. I didn't write that, but you don't have to write the whole thing up. But for Mary neglecting, I just put but for Mary neglecting to handle the situation as a reasonably prudent person, Paul suffered damages. Mary's negligence is the but-for cause of Paul's injuries. Proximate cause. The proximate cause is the legal cause where, for policy reasons, the cause would be attributed to the damages. I don't know. I'm really getting tired. I looked at that and I said I could probably write that better, but I just, better late than never. Let's get this in. Okay, so B, on the ground. This is call 2, actually. Okay, so the conclusion to this is that Mary's negligence is the actual and proximate cause of Paul's injuries discussed supra. So I'm not going to go into all that. I'm just going to get through here. This is like a racehorse. Now, the next question is, on the ground that Mary is vicariously liable for Diana's conduct. Vicarious liability, I just wrote that out. Parents are usually not liable for the torts of their children, but they can be held liable for their negligence and charged with monetary damages if filed for. Now, I didn't really finish this out. I probably should explain negligence, discuss supra, just kind of like write something briefly and then conclude that Mary would be responsible at least for monetary damages. She wouldn't be held liable for the child's tort, but she'd be liable for her negligence and then be charged money for the damages. So I did want to look at 2010 because I noticed that one had a lot of good stuff in it. And I actually downloaded it if you want to work on practicing these concepts with hypotheticals. You know, this is the thing about studying law. It's like studying algebra. With algebra, you learn the formulas, and then you have to do the practice problems. Because you're going to be faced with different types of problems. You know, like when you're doing trinomials and binomials, and you have to follow the pattern of foiling, like first, inner, outer, last. That's with the binomials in your algebra. This is kind of the same thing with law. You have to break it apart, and you have to follow the pattern, and you have to apply it to the particular problem. So this is sort of problem solving with a whole set of rules that you have to memorize and apply to the fact patterns. And so you get better at it with practice. And so that's, and then finally, you know, you practice first, and then you can practice if you practice enough and you do well enough. So that's it. Well, thanks for listening. Take care and have a great day. Bye.